The next case is State of Ohio v. Richard Boone. Again, each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. Please let me know if you would like to reserve time because I'll be keeping track of the time and the arguments are being recorded. I'll remind you to please keep your voices up and remain behind the podium. You should not use the names of children or minors or victims in your argument. You can refer to them by initials or by generic terms. And we have read your briefs and are ready to proceed. When you are, Attorney Bremke, would you like to reserve time?
I would like to reserve 5 minutes of my time.
Very well, and you can start when you would like.
Great. Again, good morning, Your Honors. Giovanna Bremke on behalf of Mr. Richard Boone. Mr. Boone must be post-conviction day because he also pled and he was sentenced actually in 2016. This is an older case. And he was brought to court for many years on violating his probation over the course of many hearings. And it eventually led to March of 2022, he was sentenced to 10 months in prison. And there's several assignments of error. I'm actually probably going to address number 1 and 3 together. And that is that his attorney failed to file a motion to withdraw his plea. But in the event that you find that it was properly presented to the court, either through him himself or through her, that it was improper.
Did your client orally request a withdrawal of the guilty plea?
There is, and I went back and looked at the record, there is a statement, there's many statements about my client. I want to withdraw my plea, and all of this talk. And the judge says, if somebody is making an oral motion, I'm saying denied. And that's transcript page 41, I'm sorry. That was in 2018. And then on the transcript 57, 58, in 2022, they're still talking about this motion to withdraw. So I would say to you, if the court was saying, first of all, it's a conditional, if somebody's filing, I'm saying denied. But second, if the court and the parties and the attorney felt like it was properly presented, why are they still talking about it? In 2022, 4 years later, they're still talking about this motion to withdraw the plea. And so whether there was no written motion, I think that's clear. But I think the state questions whether it was raised properly through my client. I think there's also the idea that if somebody's represented, they have to file motions through their counsel. So I would say it wasn't properly filed, and that rendered his attorney ineffective. If you read the transcripts, you will probably pull your hair out at the number of times that my client asked for his plea to be withdrawn, and there is the affirmative, there is the affirmative confirmation from not only the court but also his attorney. Yes, I'll file it. Yes, I'll file it. Yes, I'll file it, and it never gets filed. And ultimately, it comes to a head with him being sentenced to 10 months on a F4 non-support, which is a significant amount of time for a charge like this.
Do you think a motion to withdraw the guilty plea after the sentencing during a community control violation hearing would have been frivolous?
No, I don't. I think, and again, that kind of goes to my third assignment of error. If you decide that the court did properly consider it, then it was improperly denied. He brings up about this Pittman case, and he brings that up himself, and that's a 2016 case. So it's right around the time of his plea that this case was decided, and he brings up about the fact that his daughter was emancipated. He signed to have her married. And so what the Pittman case stands for is that, you can't go after that arrears if there's not a current support obligation.
You can't charge them if there wasn't a current one. But the colloquy on the record was that the judge, that she still had a support obligation at the time, right? So that case wouldn't apply to him, would it?
What I would say is that it's not clear to me. And the reason it's not clear is because the attorney never filed the motion, presented the evidence, and that goes to my first assignment of error. Because we're kind of going off of this bits and pieces of what my client's saying. I don't think the state really contributes much in that regard at all. The court's sort of asking questions. Maybe the attorney chimes in. But if the attorney would have filed the motion to withdraw the plea, I don't think it would have been frivolous because she could have presented evidence and, you know, either the signing of the emancipation and when that took place, when the arrears order was, if there's a current order, all of that. And I think that the outcome would have been different. So again, if the
Attorney Brumke, in support of his oral motion to withdraw the plea that he made in 2018, didn't he argue he wished to withdraw the guilty plea because his child support obligation had been improperly calculated, that despite owing $34,490 in child support arrears, he argued that he had fulfilled his child support obligation, and that his indictment was defective? Are those the arguments that he raised?
I believe so, yes.
And he could have raised any of those arguments in direct appeal, correct?
He could have potentially, well, I guess I don't know for a fact that they would have been in the record. I think that withdrawing the plea would have allowed him to explore those different, those different things. I think if he would have argued that it was improperly calculated, there really wouldn't have been a lot of, after he pled, there wouldn't have been a lot of record to support that. And that's why I think a motion to withdraw the plea would have been the proper venue. And that's why, that's why I think it's so important that this attorney is telling him, I'm going to file to withdraw the plea, and she's not doing it, and the court's saying, even transcript page 32, the court says, I've been hearing for months that there's going to be this motion about, and that was in December 2018, and then we go to 2022, so I don't think anyone's going to dispute that there was all this talk about withdrawing the plea, and I think that would have been the proper venue for it, because I don't know that these are issues that could have been raised on direct appeal.
Can you talk a little bit more about the ability to pay issue? Because I understand that ability to pay is a defense to non-supportive dependents, but there is all this law now about not sending people to prison if they don't have the ability to pay with restitution, and so I'd like to hear a little more about that.
Correct. So, I agree with you. It's a defense that if you can't pay, you can't be convicted on it. And there's, I would contend, and I don't know that there's a lot of direct law to support this, but that same principle applies on a violation of community control. Certainly there's another sentencing entry that you put on when you send somebody to prison after a community control violation. So I think the same principles apply. Does somebody have the ability to pay? And my client, and there needs to be some sort of inquiry to that, again, because there is this trend that we don't send people to prison for their inability to pay.
The only community control violation, failure to pay child support, or there are other violations as well?
I believe it was just the failure to pay the support. And maybe failure to report at one point as well, early on. But
So
mainly.
The 20, when he was sentenced, you believe the only community control violation at that point was failure to pay?
I believe,
the brief weren't clear to me.
yes, I believe so. And I'll be honest, they are pretty forgiving of, even positive drug, if you're testing positive for drugs but you're paying your support on this kind of docket, that's usually okay. They're not going to violate you on the drugs. But my client makes it clear on the record, I have no job, I have no home, I'm living with my mother. He literally says, I don't have anything. The transcript page 35. So he's making it very clear he has an inability to pay, no ability to pay. I think the Supreme Court has sort of given courts guidance on this regard. I had a case, State versus Chapman, that went to the Supreme Court, and Justice DeWine is saying, hey, if you can only be convicted if you have the ability to pay and you can't pay. And so, again, and that's what the statute says, but that is another consideration, I think, on a post-conviction. It's still the same way. It's still, having this ability to pay, not imprisoning people purely for their inability to pay. The whole purpose is to provide resources in order to get them to the point where they pay. because ultimately that's not going to solve the issue here. So I think there does need to be an inquiry even on post-conviction. I think I'm nearing my time, so I am going to reserve the rest of my time. Thank you.
Very well, you'll have your full 5 minutes for rebuttal.
Thank you.
Good morning again, and finally, I'm Rick Raley with the Lorain County Prosecutor's Office on behalf of the appellate state of Ohio. I'll, like Ms. Bremke, I'll address the first and third assignments of error together, and I do want to point this court to the Brown decision from the Supreme Court of Ohio. I think that's the controlling one in this case, and it quite clearly shows that a motion to withdraw the plea would have been frivolous. And the record is very clear. The date of birth of the child is in there. The indictment lists the periods of the non-support. That occurred while she was 13 to 15 years old and she was unemancipated. There were no grounds to withdraw the plea. And on this ability to pay issue, the brief from Ms. Remke refers to the statute 22CA011849, and that applies to affirmative defense that can be raised at trial. That would not apply in probation revocation proceedings. Anything about the restitution ability to pay, that should have been raised by him and could have been provided with evidence, and it's up to the trial judge to disregard that and to believe that he did not satisfy his burden on that point because of his self-serving comments at the sentencing hearing. I can't see any reason why that should be disturbed with appeal. Are there any questions? If not, I'd ask you to affirm the trial court's judgment.
Do you recall if there were any other probation violations other than failure to pay in this case?
I wish I could tell you that I do, but I did not look into that.
That's fair. Thank you.
Any other questions? Thank you.
Hearing none, thank you.
Okay, I think I have about 5 minutes here, judges. One thing I forgot to mention the first time around, in my first assignment of error about the withdrawal of the plea, there's a Biggers case that I cite in my brief about an attorney who was unprepared and failed to file any motions. I would submit to you, and I'm making a big deal about this, and I think the record reflects it, but this is really an extreme case of neglect. And for this court to not acknowledge that, I think does a disservice to defendants who are being represented in this manner. That they're, repeatedly saying that I have grounds for a motion to withdraw, and he does, Judge Sutton, you mentioned, he does bring up specific areas of a motion to withdraw, and you never hear his attorney say, I don't think there's grounds. There's just a repeated assertion of, I will file. The court's instructing the attorney to file, and this goes on for 4 years. So I think that's significant. I think on that assignment of error alone, there should be a remand. However, if this court does find on the third assignment of error that it was properly presented, that there would be enough to withdraw his plea and it shouldn't have been denied, or shouldn't have been denied in this manner without a further hearing. As for my second assignment of error and the inability to pay, and again, I would say that there's not direct law on this, but you have the opportunity to make law in this area and determine that there should be a consideration of an ability to pay, even on a post-conviction on the community control violation. So I would ask that you reverse his conviction on these assignments of error and send it back to the trial court.
Would it make a difference if there were other things besides just the failure to pay?
Well, I think I'm going to say a practical answer. I think sometimes that and probation would normally bring a violation, again, if somebody's testing positive for drugs, but they're paying, but then they stop paying. And they're going to flood in all of these violations. But ultimately, he wouldn't have been sent to prison but if he wasn't paying. And I think that even a colloquy from the court in that regard would be helpful to determine a person's ability to pay, so that we're not just saying, okay, you aren't paying, and assume that there is an ability to pay. And I don't know if that directly answers your question, but I think practically the court has to consider that while there may be, the record may reflect that maybe there are other violations, that there wouldn't have been a prison term if for the ability to, the payment issue, the non-payment.
Okay, and on the issue of the attorney not filing a written motion, do I recall correctly that the attorney actually said that that the client wanted him to file it, but he didn't think it would be successful? Is there something to that effect in the record?
There's something to the, I don't recall that, but there is something where the attorney's saying, I'm researching it. Whether that came of that, I don't know, but again, looking at this, even on the day of the hearing, I don't think it was the day of sentence I've been talking about, to the 10 months. Every time the attorney asserts that I'm gonna file this, I'm going to file this, even if there was something like that in the record, and then later says, I'm gonna file it, I'm going to file it, again, there's no assertion that I recall of saying, hey, I've reviewed this, I've researched it, and I don't think that I've made the decision to not file that. There's never any assertion on the record to say that, you know, that was a legal reasoning. And the judge is actually ordering the attorney at some points to file this motion. So I would say too, you know, the number of times that it's brought up, and even as late as that last hearing, that it should have been done. Any questions? I will, again, ask that you reverse. Thank you.
Thank you both for your arguments. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website.